Hello, Signature Real Estate Group. I'm Vandana Bala, one of your corporate brokers. So excited to be here today. Happy Cinco de Mayo, folks. Don't get too crazy with my background because it'll change throughout the day today. I did want to make sure I welcome everybody here today. Today is going to be our legal update from the actual attorney. We're going to talk about a couple of things, but before I do that, I want to make sure I give Mr. Chris Bishop an opportunity to do his Chris's tip of the week. You're up, Chris.
Thanks, V. Hey, guys. Here I am again from my kitchen yet again, and I'm still here. So I've been getting a lot of phone calls, and I'm here to help you guys, and love to help you with any transaction issues. And so one of the things that I've gotten a lot of calls about this week is the art of negotiation. And I know a lot of people seem to believe that it's like HGTV, and you need to get out of your Mercedes with your cool haircut and get on that phone and just create terms for your client. Well, unfortunately, it's not the way it works in the real world. What you're supposed to do is whenever an offer comes in, or you're the listing agent, you receive an offer, or you're the buyer's agent, you write an offer, you're supposed to get your client's buy-in for any processes or terms that you want to create or move forward with. And so the best idea is to create 1 to 3 scenarios that provide your client with information or a way that they could go forward. And then once they pick that way, then they're on board for the plan. The reason we do that is that liability is a horrible part of our business. You'll notice from the attorney below that he lives his life when we do stupid things. And so the idea is that if you create plans and terms and you don't get your client's buy-in, you're gonna wind up in court. And V and I can tell you, and Brandon and Todd, we've all sat on cases where agents have made decisions for their client without the client knowing about it. So just to be clear, for me, common sense is a big part of our business. Just sitting down and thinking out a good scenario that makes sense, that's a win-win for both parties, is the easiest way to do it. So whenever I get an offer in, and the terms look good, I like to point out 1 or 2 or 3 scenarios that my client could pick, and then get them on board for a move forward plan. Also, just want to remind everybody that the more that you get in writing, the easier it will be for us to defend you later. And that is Chris's tip of the week. See you guys next week.
Thanks, Chris. So one of the things that he said that was super important is you're not a part of the transaction. Stop making it a we thing. It is a client to client thing. The buyer and sellers are the clients. They're the ones that make the decision, not you. Don't do it. All right. Fantastic. That was a great tip of the week. It looks like Chris is going to be sunsetting off. Not a problem. And our essential service lady, Miss Shelly Panzarella with Prosperity Lending is next. What's going on, Shelly?
Hi, everyone. Happy Tuesday. Happy Cinco de Mayo Day. I'm hanging out at the link today because I can. So I just wanted to jump on and chat a little bit about forbearances, some things that we've heard. Obviously, some change to that as far as the lump sum. That is now not what they're saying is not necessary or is not being required by the servicers after that 90-day period. But something that we're now seeing or experiencing is people who are trying to return back in from a forbearance, and that time frame to get financing again. What we are being told is that it's going to look like 12 months from the date that they've actually got themselves caught up from a forbearance or on-time payments that they can then return back into financing. So things that we're talking through with our clients today that are considering this and maybe looking at the options for them down the road. Obviously, there are going to be times when there is times now that this is needed and required. And so just wanted to throw that out there so that everybody knows that if you have clients today that are considering this, the number one thing is to consult with their servicer, but as well, please, I'd encourage them to reach out to us just to see what it would look like potentially to do a refinance or even talk through what the return would look like. Something else that we are recently seeing because of the forbearances as well is a concern for cash out refinances and home equity lines of credit. So we are actually seeing the home equity lines of credit, the investors for those are backing away from offering this. So we have had a couple of jumbo clients who are utilizing this like an 80-10-10, who have now had to we've had to find some different investors for them to do just a 90% jumbo loan. But it is because the forbearance situation where they're not allowing for anybody who did a cash out refinance or as potentially in a home equity line of credit to take advantage of that forbearance. So just wanted to share those two topics as far as the forbearance, and then also to let everybody know that rates are still really low right now. So we are quoting rates with a 700 FICO in the 3 1/4, 3 3/8 range today for a 30-year fix. So if you have any questions about this or need anybody pre-qualified, you know that our Prosperity Lending team is here for you. So that is my mortgage moment. Thank you.
Fantastic. Thanks so much, Shelly. We always appreciate you.
Of course.
Hey, can we do a raffle before the end of it for something?
Sure. What would you like to
Let me just put
raffle?
you on.
Do you
I
want
don't
to
know.
raffle my hat?
Yes, let's raffle your hat. I'll give you 30 minutes to
Oh.
think about it, right? Or however long it takes
How
our
about this
lawyer.
hat? Do you like this
We'll be
hat?
back. I love it. I love it. So that'll be our raffle item.
Okay.
And so those of you who are on the chat, that's how you're going to win. That's where you're going to get a chance. It'll be in about 30 minutes. But listen up, because the question might come from what we're talking about next, or it may come from what Shelly already talked about, or what Chris already talked about, or I don't know, my backgrounds. So let's see, we have just recently released, just so you know, the confirmation, and I'm going to share my screen right now so everybody can see it, because our office was having so much trouble getting confirmations regarding real estate relationships from new home builders. And so one of the things that we did is we engaged our outhouse attorney. I'm kidding. By the way, David, I know you're on here. You can unmute yourself if you want. But we engaged him to create something that would suffice for that portion of our requirements, because agency is still required. I don't know if you guys have seen the broker insight that I did a couple weeks ago. You still have to disclose agency relationship, and so it's really important that the buyers understand who's representing who, especially during the new home builder contracts. So Dave, do you want to run through this really quickly with us? I know it's pretty standard and
Sure.
self-explanatory, as Ashley would say.
So the idea was that we would mirror the confirmation section of the RPA. NRS 645 and NEC 645 require this confirmation of a real estate relationship. It used to be a standalone form until the division came to the association and requested that it be incorporated into the RPA. So that's why you don't have a standalone form. Unfortunately, the builders don't necessarily use the GLVR form or LVR form. And so we created one that you could use with new builds that is essentially similar to the RPA. If you get pushback from the builder's agents, this is a statutory requirement. This is a division thing. This is not a signature. This is not you being difficult. State statute requires this, which is why you're asking them to execute it.
Correct. And I think the important thing here is you need to send it, right? And if you, for whatever reason, are getting pushback from the builder from signing it, this section right here, you can actually just, one, I'm happy to send you the FAQ from the real estate division that states that it's a requirement. And two, you can just, if for whatever reason you're still getting pushback, get one of the brokers involved. That email will be extremely important. The fact that they've seen it. I think most importantly, the buyer needs to acknowledge that you are not, that they're not being represented by the builder or the seller. Oh, look at that. I still left tenant and landlord in there. Dang it. I'm going to remove that portion before we upload it again. Sorry, Monica, if you're listening, it looks like I've got a correction that needs to be made, because you will never use this form for a tenant and landlord section. I will fix it by the end of the day. So the most important part is that the buyers understand that we are their broker. And this is primarily just going to be used for the new home build contracts, because we have no need for them in any other scenario that I can think of. Anyone? Going on?
No, it's already incorporated in the RPA.
Fabulous. Okay, so there's that. Now, the one thing we talked about this last week, and so I want to make sure that we address it again this week, because there's a couple of discrepancies in the way that our listing agreement is put together, in as far as like with clear cooperation, with office exclusivity, and a couple of things there. And so we figured it was important to get our attorney to review this with us. Dave, you just let me know how we scroll
Sure.
through so that I can make sure we've got it.
So unless you're a nerd like me who just enjoys reading the listing agreement for kicks, sections 17 through 21 are the sections that were changed in the most recent update that have to do with the clear cooperation policy. And so I thought it would be prudent to go through this, because if you are in a scenario where you are going to have the office exclusive form, I want to point out the things that I'm concerned about here for liability purposes and make a couple of recommendations. So the first section is District 17 explains that that you are a member of the association and that the property will go into the MLS. 18, and it talks about 18, 19.
I'm going to stop you for a second, because that section hasn't changed except for to mention the other sections that now apply to it, right?
Correct.
Okay.
18 was also pre-existing, and this is the language that we put in to protect you as a seller's agent regarding advertising out on the MLS. You would be surprised the number of phone calls the association gets from someone saying, my home is, pictures of my house that I bought 2 years ago is still on the internet. And they seem to think that there's some ability to remove those photos once they're online. So 18 is designed to do that, and also convert and explain that the photographs, the listing information is the ownership of the brokerage, so that the association can file its trademark and keep the collection protected. 19.
I'm going to stop you again.
Sure.
Because this is going to be one of those things, right? And Brandon, if you're monitoring the chat, will you just let me know if somebody has any like burning questions in regards to this? So for 18, marketing and advertising, the only stuff that's really changed in here is that now the seller has to authorize or not authorize the broker to commence public marketing and advertising, right?
Yes, and this is something that I think could be potentially problematic, that I don't know if they went through. If you decide,
we got nothing. This is, I mean, it just got loaded. There's no
we'll
white paper.
with,
there's no video. I called the MLS chair and she was like, they did what? I'm like, yeah, there's a new listing contract.
The problem here is the fact that the seller now has to initial. This is going to become a problem for you down the road, because if you change that status, and remember, you only have one business day to do this. If you decide to change and say, start marketing, public marketing and advertising events, what 29 and 30 does makes it what? Makes it a contractual decision that the parties have decided, which means that I can't just call you as your seller and say, let's start marketing advertising. Guess what you have to do? You have to amend the contract.
Change order form,
you have to do a change order. Everyone has to sign it, and it's got to be done. Now that time frame is going to be very critical, because you only have one business day to do this. So if you market before the seller executes, you could have some problems there. This is something that I don't know why they went with these initial sections. 19 is the sign.
I think it's probably because and when we were on forums, you had said, well, you realtors really like to have your clients initial everything to make sure they understand it. So I think it's an opportunity for the sellers to really stop and pay attention to what this is doing, because there are sellers. I mean, I got an email last week from an agent who no longer works at our company that is asking, because the seller said, my house is still on the market, or still showing, pictures are still showing up, blah, 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 you know, can you take them down? I mean, once it hits the internet, it's out there, right? Which is why we don't send pictures of ourselves doing stupid things. Because once it's out there, you can't run for president anymore, or you can, I guess, now. Not going to get into politics. But anyways, so 2930, I'm going to assume that the reason that that's there is so that it could stop the seller from proceeding and just clicking the sign button and really understanding or knowing that they're giving up or giving authorization to the broker to do these things and what it means. The language is crap. I mean, it always has been. No offense.
That's the problem, that what they've done here. There's no explanation in 17, 18, 19, or 21 as to what the clear cooperation policy really means in layman's terms to the seller. There's
Right.
nothing here that says, look, if we pull it off the MLS, that means we can't advertise it anywhere. No Zillow, no Realtor.com, no third-party portal, no Facebook, nowhere. There's nothing in
MLS.
this there's nothing in this document that says, I, seller, understand that if we do this, it won't be anywhere else. There's a little bit of language in 21, but it's incredibly unclear. And that's the thing I think is the biggest concern, because the way I look at the initial box as a seller is, well, my agent pre-filled the does or does not part, and I just put my initials in there through DocuSign. You were the one who made all these selections, and I just initialed it, and you didn't do a good job explaining it. So I see a lot of potential liability here for the way the form is set up.
So I mean, I'd even continue to argue that like there's the clear cooperation isn't really showing up in here right now yet, right? But you're asking the seller to understand what that means, even though it's in section like 21 or some nonsense, right? Because
Yes.
it doesn't show up until 21. That's when you hear the clear cooperation, but you're having them initial in section 18 regarding that. Now, I have a question for you. Does this mean that they can't, if the seller marks it does not authorize, they can't mark it in the MLS? Would this be like an exclusion to the MLS without getting it notarized? I feel like that might.
No.
Okay.
The way that the policy is written, there's a disconnect between the forms and what the policy says. The policy states that you have to either put it in the MLS within 1 business day or submit the exclusion form. The exclusion form, which we'll get to in a minute, actually says you have 2 business days to do that, on top of the other errors in the form. So this is an incredibly confusing section. I would tell you, at least in the short term, until they hopefully fix this, is that I would be very clear with my sellers what the consequences are of having an office exclusive. And if you don't do that on a regular basis, I don't know if now is the best time to start to figure out that as a business policy, because the form doesn't do a very good job of clarifying what the consequences are. And the exclusion form that has to be notarized doesn't even reference the specifics of the policy at all. So the seller, because of these inconsistencies, a seller could really say, yes, I signed all this stuff, but it is so confusing and the forms are so inconsistent that how do I know what I'm signing? So that's the concerns that I see with this.
So what's a good way for someone, an agent, because I don't want to freak people out, because I know we're talking about inconsistencies in forms and this and blah, blah, blah. But what's a good way for an agent to explain section 18 to their clients? Because that's really what everybody wants to know, right?
And it's actually, you kind of have to explain 18 and 21 together. And I think the best way to explain it is, I am a realtor. I'm a member of the multiple listing service. Everybody understands what the MLS is. It's that way that you can look at houses online and all that data. And the explanation, I think, has to be that if we're going to not put it on the MLS, that means that I can't advertise it publicly anywhere. So that means that no Facebook, those kinds of things at all, and have that conversation with them. I don't think this is the death of exclusions from the MLS. I think it's going to be a lot harder for sellers agents to justify why it's being removed from the MLS. The best piece of advice I have for you is, unless the seller doesn't want it on the MLS, I don't know how, with the change in the policy, it's going to be easy for you to use a quote unquote pocket listing anymore. So if your policy is always, we believe in the MLS and we're going to upload, then I don't think you need to really go through and have a whole lot of explanation aside from part of what we're going to do to market your homes. We're going to put it in the MLS. The MLS then sends out that data to all of those third-party websites that you want to make sure that you're listed at, and do it that way. but explaining how it is in my best interest as a seller to keep it internal in your office with the way the form's written, I haven't figured out a good way to do that yet.
So let me paraphrase, and by paraphrase, I mean completely actually answer my question, is you could do for section 18, primarily just say, I'm a member of the MLS. Anytime I put your property on the MLS, it will be advertised to different media sources, right? It will be syndicated to thousands of websites. And I also don't have any control of what happens with those photos once the property sells. In fact, because I'm a member of the MLS, and that's probably why you hired me, is to get your home marketed to as many people as possible. These images that we take could be available on the MLS for years and years and years. And therefore, you need to understand that I can't just remove them once they've been put up there. So you're signing off to say you're good with that.
Yeah. To me, I think that's your best way.
Right?
Yeah. If you're going to do an office exclusive, I would tell all the agents watching, go speak to your broker before you do it, because the timeframes are so tight. If you're considering it, I would have the conversation before you start any marketing. I noticed over the weekend, because this policy officially went into place on Friday,
yeah.
I noticed at least 7, 8 violations or advertising that wasn't listed in the MLS where the agent actually said it in their Facebook post, not on the MLS yet, but look at this great stuff. I'm like, okay, well, I hope they enjoy their $1,000 fine unless they have the exemption form notarized by Monday.
Right, but they have the 2 days to do it, the exclusion form, and 1 day to put it in the MLS, right? So it's technically just 1 day.
It is 1 day.
One business day, one calendar day.
The policy says 1 business day.
1 business
day. The
day.
exclusion form says 2.
Okay.
And so the form is in direct conflict with the policy. So hopefully they will fix that. Okay. So it is 1 business day.
I know you're itching. I know you're itching to get to section 21. So let's just run through 19 and 20 really quickly, because there's no changes. 19 is the exact same, but what it does say now is that the seller cannot even authorize the sign if they haven't authorized the marketing and advertising in the section above.
Correct.
So that's the only difference. So that needs to be really important. So no sign if no authorization to commence public marketing and advertising activities.
Yes.
Okay. Seller opt-outs, very similar. Nothing's changed in this section, right? It's been the same. This ultimately says that the seller does not want any commentary to be allowed. Now, how accurate that is, we still don't know. I know that sometimes we've pushed the no commentary, but really, once it gets syndicated, how can we?
This is all
or the AVM.
Yeah. This was all language required when the Department of Justice and NAR had their lawsuit in the early 2000s. So the language was required there as part of the consent decree. Technology has moved beyond the consent decree, which expired last year. So that language hasn't changed. NAR isn't changing away from that. So that's required language, and I don't know if NAR is ever going to change it.
Okay, so nothing's changed, so no real reason to talk about these. Now, here's the section that I know you're just jonesing to talk about.
This one is interesting because it's not clear exactly what I read this as a real estate attorney and someone who's bought and sold homes, and I'm still a little unclear as to exactly what this says. And so this is the language that if you get sued, if the seller turns around and says, you didn't tell me that you weren't going to market my property in every portal available, you were just going to keep it inside your office. This is the language that's supposed to protect you. And say, no, seller, we explained it. And it just doesn't do a very good job describing it. So I know what they did. It looks like they literally cut and pasted the policy language from NAR there, beginning with Further, seller acknowledges and agrees that if there is any public marketing of an office exclusive listing, then the broker must submit the listing to the GLVAR MLS for dissemination to its participants within 1 business day of public marketing. And then they decide to define public marketing. Flyers displayed in windows, yard signs, digital marketing on public-facing websites, brokerage website displays, including IDX and VOW, digital communication marketing, email blasts, multi-brokerage listing sharing networks, and applications available to the general public. That's clear as mud, right? Everybody understands what that language means.
No.
And that's the concern, because that's the language that, you know, if you're going to do this, I think they needed to do a better explanation as to why. So I see potential liability there because it is unclear. I don't know what an IDX is or a VOW as a layperson. What exactly does this mean? It doesn't say. It means we are unable to market it anywhere to the public if it's not on the MLS.
So one of the things that interests me here is line 21, right? Where it says seller does or does not select an office exclusive listing, but seller may not select this option if they've not authorized, or I can't even read the rest of it because everybody's, hold on. If seller has authorized marketing, advertising in section 18. So that, I mean, I feel like cannot select which option, the does or the does not option.
It is incredibly unclear.
Okay, so they can't select, I'm assuming it means they cannot select an office exclusive, right? If they authorized, if they said does in section 18, they cannot say does in section 21.
Yes.
It must be the opposite.
Yes.
That's how I'm reading it.
Yes. And okay. I see a lot of potential for agents to, as they're zipping through this, to select the wrong one or scenarios because they're nowhere close to each other. It would be ideal if the explanation of what public advertising is, you know, I authorize you to advertise property to the public, yes, no. If no, I understand it is an office exclusive and the form has to be executed. It would have been cleaner to do it that way. But
right, so section 18 says no, then that automatically almost has this one saying yes, right? So if they say does not in section 18, it automatically should be does here in section 21, but then you need an additional form if they execute with does on section 21 for the exclusion that needs to be notarized.
Correct. And submitted within 1 business day.
Perfect. Clear. 100% clear. Did everybody understand that? Yeah, perfect. All right. So are you done with that section? Because I've got a headache. And it's only 10 o'clock.
The simple answer is the 2 pieces of advice I would give you is 1, if you always advertise in the MLS, your business model hasn't changed. If you are an agent who tries to do office exclusives to double in deals, it's become a lot more difficult for you to do that. I almost feel like this MLS policy, it's not a rampant practice here in Southern Nevada, it is in other markets. And I almost feel like I'm talking to my daughter when she was like 6 saying, we now have an office exclusive rule because, you know, this is why we don't have nice things because someone abused it. And the idea behind the MLS exclusion was there are unique scenarios where a seller doesn't want their property in the MLS. What was happening is people were using that and then in an attempt to, you know, try to, you know, a pocket listing or double in the deal, if you will, which is, so that's what this policy has come from. And, you know, the sanctions, I'm sure you talked about it, are pretty severe. It's $1,000 for the first offense, 5 every thereafter, and then they can drag you in front of the MLS board, and the MLS board has the ability to remove or suspend your MLS membership. So the sanctions are very severe for this.
No. Okay. Use of listing content, section 22. This has always been in there.
Yep.
So there's no change to this.
There's no other changes to the form as far as I can see.
Well, the 1031 section, right? It is right down here where it's been added. First of all, this right here, the fact that line 1 on this page and line 1 on page 2 drives me cuckoo, right? But they added section 36 here, which is the 1031 exchange section, just saying
Yep.
that the seller intends to perform the section 31 exchange. And that we talked about last week. Brandon was on forms committee when that change was requested. And so that made it. Now, probably in the next,
That was like a year ago.
yeah.
Wow.
So
Okay.
probably within the next month, you'll see an additional change because MLS is going to be meeting. It's going in front of the board for the UCS versus UCNS. And that change will also show back up on most likely section 37 or even higher somewhere, where the seller has to make that determination once they've accepted the contract, if they want to go into UCS or UCNS status. And if that status changes from the moment that they sign the listing agreement to when they accept a contract, they'd have to do a change order to fix it.
Yes, it's not valid if it isn't that way.
Correct. So many things to think about. And of course, the other thing that they've changed is they've added time in here. We talked about that last week as well. The reason that the time is in here is to really cover your butts to make sure that you as a practitioner have taken the time from the moment that a client signed the duties owed to the time that you have had them execute this document to discuss with them what this document means, right? If every time is 10:04 a.m. on every document, well, technically you haven't taken the time to explain it to them. And so that would be where this would come in for the real estate division.
Yeah, I'll be honest, I don't agree with this change because I think all it really does is gives an opportunity for an agent to potentially create an ability for the division to come in and say you didn't do time frame correctly.
Right.
So mind the time frames there, because all the adding the time in is all it really is a speed trap, if you will, from the division to catch speeders on the 215.
So we've got the same issue here. I mean, not the same issue, but the same thing happening here is where the broker's time needs to be completed as well for when they signed the document. So not just dated, but now timed as well. The one thing I will tell you is that that's caused a real problem. Like when I'm seeing contracts come through, because agents are so used to putting the date that they didn't account for the time section. I'm actually not signing the listing agreements until the time is in there, because that's extremely important to have, again, to cover your butts. All right, so already know exclusive brokerage agreement must be signed by the broker to be authorized, to be valid. So that's important. And then they added this. So last week, this wasn't here. Page 10 was missing, but it was part of the original contract as page 9. So the one thing that's happened is that this contract's become a little bit longer. It's 1 page longer because that page 9 is now this little section where it needs to be signed by the broker, which I think if they fixed some of the spaces issues, it might actually show up right and be 9 pages again. Who knows? Okay, so that's all I got on the listing agreement. Was there something you wanted to review specifically else in the listing agreement that you thought was relevant enough to talk about?
No.
No, that was a really easy answer. Okay. And then we've got a couple of other things going on in our marketplace that you wanted to touch on from a legal perspective. So have at it, my friend. Floor is yours.
A couple things. Because of COVID, the court systems have taken a dramatic cut. They've bumped everything that has a trial date out for a minimum of 6 months. Evictions have been stayed, as we all know. The neighborhood justice center that does mediations is closed. So earnest money disputes are becoming a little more difficult to handle if you can't get it resolved between the buyer and seller right now. We can submit paperwork to the association, but there's going to be a massive backlog when everything opens back up.
I'm going to back up for a second because we had an incident with a client. It was an EMD dispute. And when I called the association and said, hey, are we still mediating public to public? I was told if the contract was written after April 2019, we no longer handle public to public mediations.
So If that's the case, then the mediation provision becomes a little more difficult because you have to do it in Nevada now. The law says you must mediate if the provision is there.
Our contracts say you must mediate.
Well, but more importantly, the Supreme Court has said if that mediation provision is there, you have to exhaust it first before you can file a lawsuit, period. If you don't, you'll be responsible for the other side's attorney's fees. So what it has done is, you'll have an EMD dispute, buyer and seller say, okay, now we're gonna file for mediation. Where? And more importantly, the low cost neighborhood justice center, they like that one because they will do it for free. Most professional mediators charge anywhere from $350 to $550 an hour with a minimum of 3 to 4 hours up front, even if they're doing mediation by electronic means. So what has happened is if you have an earnest money dispute right now, it is ideal that the buyer and seller reach a resolution if they can, because what will happen is when the neighborhood justice center opens back up, there's going to be a massive backlog. To put it in perspective, GOVR typically handled anywhere from 150 to 200 mediation cases a year. They're now going to dump those to a new venue. So
are those public to public? That's how many they handled public to public a year?
They handled more
moly.
public. They handled more public to public. The number one thing professional standards did, believe it or not, was the public to public mediation by far. You ended up usually having anywhere from and maybe 50 to 75 arbitration cases and roughly the same amount of ethics cases. But by far what professional standards did was these public to public mediations. They're no longer going to do them. So they've got to go somewhere else. Plus all of the other mediation attempts for lawsuits and everything else. So if your buyer and seller are going to have a dispute over an EMD and they can't reach a resolution together, it could be 2021 before they get that mediation hearing. So just keeping that perspective alive that yes, you can go and mediate, yes, you can go fight over your EMD, but with everything that's going on right now, you're going to be in a holding pattern for the foreseeable future because there's no clear indication as to when those places will be opened up again under the governor's phase plan.
So it's almost, or it is better to just mediate for the clients as agents or brokers. Let's get the buyer and seller to some form of agreement because this could take 2 years. And what's the point in that?
Particularly,
right?
Yes, particularly because of look, if it's a large amount of money, we're talking $15,000 to $30,000, I can see what people are fighting. If it's 2 or 3, in a time right now, it might be beneficial. I will also tell you, I don't think that a judge is going to look at a seller trying to take advantage or looking at the COVID-19 as an opportunity to secure earnest money. I don't know how they're going to take that. I also, so if a buyer is terminating for anything directly related to COVID, financing, lose their job, those kinds of things, I don't think a seller has the leg to stand on at this point. But again, we're going to have a long delay before that comes in. It'll be another discussion once we kind of filter this out, if executing the mediation provision is in your best interest in the agreement. Because once you sign it, you can't back out. If I refuse to sign it, I can always decide down the road to mediate if I want to. But the landscaping is changing on the mediation provision, and I haven't decided if I think if it's a good idea to execute it or not.
Got it. I know that we have a question, Brandon.
So Dave, quick question. If we brought the buyer and seller into the office and sat down with our brokerage and the other broker and tried to mediate it out that way, would that count as mediation in the provision? No, and I'd be careful with that in the sense that at some point, an earnest money dispute stops becoming a real estate transaction and becomes a lawsuit. And the concern that I have with this is the definition under Nevada law is extremely vague.
The definition of practicing law in Nevada, and yes, it was brought to you by Glenn Lerner, and no, I'm not kidding, is advising any individual on any right, on any issue that impacts any legal right. So apparently everyone in Nevada is a lawyer under that definition. And the Supreme Court specifically came out and said, we are not going to give you a bright line test. It's going to be a field of gray based on facts. So I think that anything that you could do to encourage a buyer and seller to reach a resolution would be good. If it was some sort of formal setting, I think that potentially, depending on how the agent's involved, I mean, if they're there and the buyers and the sellers are the parties negotiating, I think you'd be fine. If you had a formal mediations provision session and the agents participated, that could be interpreted, like advocated on behalf of the client, that could potentially be defined as practicing law without a license. So so it could potentially, so the answer is that if you wanted to just provide a facility for the parties to do so and let the buyer and seller attempt to work something out, that could work. The RPA has changed. You can pick a mediator, whoever you would like to. The parties agree that they want to have, Vandana or Chris or whoever mediate on behalf and be that third party facilitator. That would work. There's not a requirement. There's not a special license that's required to be a mediator in Nevada. You don't have to be a lawyer. The programs that have mediators, they typically have training, but there's not like a specific certificate that you would get from a division. So
the division does. I'm sorry, Brandon.
You've gone through mediation training.
Mm-hmm.
Yeah, I have.
Yeah.
Yes, I've been through mediation training. I haven't done it through the Justice Center. That's probably going to be something that I do as part of my end of year goals, which may, go into next year, but who knows. But I think I definitely want to do it for not the Justice Center, the neighborhood Justice Center. They have a program that's pretty robust on mediation, but I did do the one from, the one from NAR. I went to that a couple years ago.
Yeah, to put it in perspective, the foreclosure mediation program requires either you to be an attorney in Nevada or have taken a minimum of 40 hours of mediation training. And then they require you to either have been a mediator for 10 sessions, co-mediated for at least 20. So that's the policy they have for it. But no, there's nothing stopping you from, attempting to create some sort of mediation process that would step into that gap, because I see that as a potential issue going forward is how are you going to get affordable mediation services aside from the neighborhood justice? Because, GLVR's whole perk was that it was relatively inexpensive. But if you wanted to hire, for example, a professional mediator from JAMS or the arbitration disputes, they're going to want $300 or $400 an hour and a minimum of 4 to 5 hours of cash up front. So it could get extremely cost prohibitive on a $1,500 investment dispute.
Okay. All right. What else you got?
The last thing I wanted to talk about was, as we are starting to move forward with reopening the economy, I want to remind you, as crazy as this is going to sound, your potential liability related to COVID-19 exposure is actually going to go up dramatically when the governor's restrictions go away. There is a big push in Congress right now to try to include some sort of indemnification for businesses reopening. So, the time to stop, your CDC guidelines, the spacing, the gloves, all that stuff is not when we reopen, because that could be the potential time where you're going to have more exposure. So as crazy as it sounds, you arguably have less liability related to COVID-19 exposure now because everyone's under a lockdown. When that changes, there is going to be an increase of cases based on what most of the CDC and medical experts are suggesting. And there are already lawsuits being filed by employees alleging they're not being protected by people who are arguably been exposed. So I would tell you that you probably need to be even more vigilant if the governor opens everything up after May 15th than you are now, because that potential liability for exposure is only going to go up.
So don't let your guard down, essentially, right? It's just because we're back to business doesn't mean it's business as usual.
No. And from what it looks like, the political lines on Capitol Hill in Washington, the next stimulus package could pretty much determine to come down to whether or not they're going to provide businesses protection from COVID-19 lawsuits. I mean, I'll be honest, I don't know if you guys noticed this or not, but there is a plaintiff's personal injury firm in Las Vegas that has already sued China for exposing COVID-19. The state of Missouri has done it as well. Those are not going to go away. They're only going to increase. And so, particularly because of the nature of real estate, you have an added, anytime anyone goes into a seller's home for any purpose, there's a potential exposure to COVID-19. So just be mindful and careful and take those steps and make sure that you're communicating, the efforts you're taking and those guidelines to your clients, so you've got that paper trail. So
do you have any recommendations of what that should look like?
Well, there's a couple of things. I think that just having a standard form or some sort of email or marketing tool that says, these are the things I'm doing to help you stay safe during this time period is essential. I think that explaining to your buyers in writing, this is what will happen when we are allowed to go back and visit tenant occupied properties again. These are the things you need to do. And I think that needs to be in writing. That's what I would say. I don't, indemnification forms are helpful if you can get people to sign them, but more importantly to me is just making sure that you're putting it in writing when you're sending that to your clients.
So that COVID-19 notice that you actually created for our company, was that one? That one is probably, it would suffice for now as well?
Yeah, I would, yeah. Definitely.
And that we could use that for buyers that are coming into our listings. So have that form available right in the document section within the MLS and have potential buyers sign that before they're authorized to go into the property. Specifically if sellers or tenants are worried about this, right, for now.
Yeah. And then, at some point when open houses come back in some form or another, I would probably want, in addition to the sign-in sheet where your people are signing in, that there's the acknowledgement and the hold harmless. And we can create a form like that if and when open houses ever come back.
Yeah. I'm actually going through the chat. I lost Brandon for a minute. He walked away. But there were a couple of questions that came up in here. So will our company confirmation be required if we have a version of it in the contract? No. So if you're using the RPA, then the company confirmation that we've created wouldn't be necessary, right? This is primarily for, excuse me, those buyers that are buying property through builders, and the new home builder has not provided you a confirmation of any sort. So you have that requirement in SkySlope where you have to upload the confirmation. But if the builder isn't providing it to you, then you have an avenue to find it because it's no longer available in Transaction Desk. That was the one complaint that I was getting all the time was, I understand that you're requiring it, but where are we supposed to find it, right? How are we supposed to do it? And I have a duties owed. Is that sufficient? No, the duties owed does not suffice for agency relationship because it only tells the buyer that you represent them. It doesn't tell the buyer that the seller builder does not represent them, right? So you'd have a confirmation that would apply only for new builders. The other one, let's see. If the seller marks that does not have, do we put a picture of the front of the house in the MLS? Well, that's an interesting one because you have to put something once you upload in the MLS. Well, there's actually an MLS photos exclusion as well, right? Photos from the MLS. Now, would that suffice for the MLS rule stating that one picture must be uploaded and it must be the front of the house? Do you know, David?
So let me make sure I understand the question. Is the question that if the seller says, I do not want the property,
marketing or advertising,
like an advertising, then I think you submit the exclusion form and you don't submit anything because I told you that I don't want it marketed anywhere, including the MLS. So the one photo requirement I don't think would apply because if they mark does in section 21, and this is going to be confusing, and does not in section 18, meaning no public marketing under 18 exclusion from the MLS under 21, then I think that you submit the MLS exclusion form. It's notarized, and you don't put an MLS listing in because I've told you not to.
Okay. So then you wouldn't upload the front of the picture because you're not uploading the property into the MLS anyway.
Exactly.
But you have an
Yeah.
MLS exclusion signed and notarized by the client.
Yeah.
So one of the questions that came up was the bigger picture is what value would a listing have if it doesn't want to be marketed? Well,
You're the real estate professional. You tell me.
I mean, if we have enough people that are looking for property within our company, but then the office exclusive must be marked as well, right? So
if your business model was this kind of exclusive issue, they have made it a lot more difficult for you to do it. Next couple of questions people ask: no, you can't opt out of this policy. Well, I guess you technically could. You'd have to quit being a realtor, but you could. That would be the only way to get around it. And then the only practical piece of advice I would give you on this, and you're going to laugh at me, but I would say if you're going to start your marketing for a new listing, start your marketing and advertising on a Friday.
what? Oh, so that Monday is the new date. So you've got the two and a half days or whatever. Are you giving us ways to get around the policy?
No, what I'm saying is do yourself a favor. If you know you have to upload it in the MLS within one business day, and you're planning out when you're going to start your marketing, why wouldn't you start on a Friday? That's typically people look at houses more on the weekends anyway. That gives you an extra 3 days to submit the paperwork to the MLS. So you could do the whole, this house is coming on the market this weekend thing on Friday, and then submit the paperwork by Monday, rather than if you did that on a Tuesday, you'd have to have it in by close of business on Wednesday.
Got it.
So
Cool. All right. What else you got for us, Dave?
that's about it for right now. Just stay safe.
I see Chris coming back. Does that mean you have a comment, Chris? Because that was your question about what's the point of marketing the home or not marketing the home. Why would that be a valuable listing at all?
Yeah, I mean, it wasn't really a question. It's the point. What value does a listing have that doesn't want to be marketed? I mean, that's like me saying I don't want to put a sign up. All these things are for, the legal dissertation from Harvard. I appreciate it. But all the ideas are basically conversation with the seller, right? You want to sell your home, you want to get the highest price possible, but we're going to give you 30 ways that you can opt out of marketing it at all. And I think, as Dave will say, because we've had this conversation over many, many years, those are all different lawsuits that happen because of an agent's inability to explain the process to their client and a client's inability to understand it. So Dave, thanks. It's always a good time.
The only time I can tell you that I think this is a valid thing is if I, as a seller, have a legitimate reason for the property to not be on the MLS. For example, I am in federal law enforcement and I don't want my property listed on the MLS, or I am some kind of safety kind of thing, those kinds of things, which is really what the MLS exclusion was supposed to be. Is if I, as the seller, have a legitimate reason because I don't want it on the MLS, then that's a question. Now, those could be, I don't think those are going to be very, very common. I would say probably less than 1% to 2%. Whereas before this policy came through, there were brokers nationwide that were, intentionally doing this, whether or not it was in the best interest of their seller or not. But you're right. I don't know what value it would have from a straight out marketing point of view.
And I think with the point you made with those protected, most of those, we've moved the client out of the property, so now it's vacant because they've been transferred. I had an FBI agent just last year. He got transferred back to Langley, and he wasn't living in the property anymore. And so, it's just about making accommodations. But you're right. If you really get down into it, most agents are trying to understand the legalities behind it. And by the time they get it, they're going to change the form again. So.
Well, I started with GeoVR in 2013, and this was a pressing issue before I came on, and it took them, 8 years to come up with this. So who knows?
I see another question in the Q&A from Patricia. If we need a hold harmless sign by vendors, for instance, inspectors, appraisers, so on and so forth. So I'm the notice that we put together that's specific to buyers, right? Is it?
The idea was that if a professional is being brought in, then they probably should be worried about their own kind of form. You tell me how, it seems to me that based on just the ability to stay open as an essential business, that they're taking the steps necessary to protect themselves. We could certainly look at whether or not we want to have some sort of indemnification for every person coming in. The lawyer would say, have everybody sign in, but I don't know how realistic that is. So you tell me, is this an issue that we need to address? Are photographers and inspectors not showing up with gloves and masks and trying to get infected with COVID?
Well, what I found that there are definitely different people doing different things, right? Everybody is reacting a little bit differently. We need to be kind to them in regards to the way that they're reacting to this, because it's their decision, right? I haven't found an issue with my inspectors or appraisers or vendors not coming prepared, but I don't know. I don't think it's a problem. But if you want, I think that if you should probably have a conversation with them about making sure that they're gloved and whatnot. I mean, I anytime my sellers, the sellers that I represent, leave the house for any reason, whether it's an inspector or an appraiser or showing a property or anything, I tell them turn on all the lights, open all the doors, so that way nobody has to touch anything. You have gloves available, you have booties available, right? Make sure that they're wearing them. You can have masks available if you want, and then just let the buyer side or the appraiser or the inspector know that these items are available for you. You don't really, I mean, with an inspector, they're touching everything, right? And they're probably cross-contaminating the entire house. So I prep my sellers for that as well. I think that might be one of the things that you have to do, is just prep your sellers.
I think that's a good idea. Yeah.
All right. I think we've answered most of the questions. Patricia, we'll get back to you maybe offline, because it is 10:30 and I want to make sure we get off a little bit on time. Well, it's already going to be late. So questions for the raffle. Shelly, you back up? Thanks, Dave. We appreciate you.
I'm here.
Are you
What do
on?
got?
Perfect. I'm so in love with your background.
Thank you.
I'm totally gonna, I'm gonna do it.
Who's that guy?
Yeah, the background that doesn't include your husband. I'm legit gonna just steal it right now. It's gonna happen. All right, so questions for the raffle. Are we doing a gift card?
Yeah, let's do a gift card.
Amazon gift card sound good?
Great.
Look
Just
at me,
make
I
sure that
stole your
get the email.
background. All right, so Amazon gift card, it'll be sent by email, so that way you get it. You have to get all three of these answers correct, okay? It's a three-parter, three-fer. So the question number one, and don't start typing and pushing enter. All three of them have got to be part of the same answer column, because it'll be too hard for Brandon to figure this out. Number one, can a seller authorize a sign on their property if they do not authorize the marketing and advertising in Section 18 of the listing agreement? I just said don't do one answers. All right, number two, does the duties owed suffice for confirmation of real estate relationship? And number three, Shelly, you asked this.
How do you spell forbearance?
So there's your questions right there. I've got no forbearance. It looks like Tanya. Nope. Aaron Patrick. Dang, Aaron, you are quick on the draw with these things. So I've been doing these during my classes as well. Aaron Patrick got it first. No, and forbearance. Nice job, you guys. I love that Todd wrote no, and with an F. It's amazing. All right, you guys, that wraps up our sales meeting for this week. Thanks so much for joining us. We appreciate you being here. Thank you, Dave. Couple of reminders. We are doing virtual office hours every single day, Monday through Friday, from 10:30 to 11:30. Most of the brokers are on there. We will be on there right after we're done here. Do not forget our virtual happy hour. Prosperity Lending actually hosted a bingo night for us, and damn, were we competitive? I think my son was pretty upset that we didn't win, but congratulations to those who did win. So Friday, join us for our virtual happy hour. And then we are having Miss Corey Henson actually do a tricks and tips for the gram, also known as Instagram. She will be she will be providing tips and tricks for that on Thursday during our office hours. On Thursday, it'll be a quick 15 to 20-minute thing. If you have questions, you're welcome to come on regarding the gram or any other broker questions. We'll start answering them right after Corey's done at about 11 o'clock. And that's a wrap, you guys. Go make it a great week. Go sell some stuff. And happy Cinco de Mayo. Don't forget, Taco Tuesdays. Bye.